Okay, next case is 14-380, McDonald et al. Versus Busch et al. Council, whenever you're ready.
Yes, sir. May it please the court, Fred O'Neill of Orlando for the cross appellants, Mr. and Mrs. Busch, Jeffrey and Susan Busch. I'd like to reserve 5 minutes for rebuttal, too. Bottom line, Your Honors, the defendants, the cross defendants below, the cross appellees messed up my client's title. My clients had to hire an attorney to clean up the mess the cross appellees made of their title, but the net effect of the 4 interlocutory orders that are mentioned in the brief, the initial brief, by the lower court, the net effect is that the cross appellees, the people that messed up my client's title, are let off the hook for paying the cost of cleaning up that title. The facts of this case are similar to the facts of the Flesher versus Oak Run Associates case out of Marion County, in the sense that they both applied, the courts below and the court in the 5th District in Flesher applied the Florida law, long-standing Florida law, that an amendment to a set of covenants and restrictions has to be consistent with the original scheme of development. But unlike the Flesher case, which dealt with one amendment to an existing set of covenants and restrictions, what happened here was an attempt by the cross appellees to create an entirely new set of covenants and restrictions. In the brief, I pointed out the distinction between the original scheme of development, the original covenants and restrictions, and the one that was attempted to be put in place by the cross appellees. Certain things that I think stand out are, under the original scheme of development, the original covenants and restrictions, there was no common property. There was no provision for acquiring common property and then turning around and assessing, specially assessing homeowners.
Let me be sure that I'm
Yes,
clear
sir.
as to the non-director homeowner defendants.
Yes.
Your complaint was alleging that they basically impacted the title of your client's properties because these defendant homeowners signed the joinder and consent form?
Right, and the joinder and consent, the way the original covenants and restrictions, yes.
Those non-officer homeowners.
Right.
They merely signed the forms. They didn't record those forms, did they?
They didn't do everything that was necessary to slander my client's title by themselves. Other people did other parts that were necessary to do that. What they did was a necessary part for my client's title to get slandered. They signed the signature page of the 2008 amended and restated declaration. The signature page, the little joinder that they signed, said that this is the signature page, we consent to it, we join in it, and that these documents be incorporated into the amended and restated declaration.
Homeowners in the subdivision, it's been suggested to them by the board of directors that we would like everybody to contribute $100 to pay for the annual maintenance of the grounds, et cetera, et cetera. Right. Are you in favor of doing that and amending the declaration and the restrictive covenants? And so the homeowner gets it in the mail and doesn't know your client and says,
Right.
well, oh yeah, I'm okay with that. So I sign and I send it in, and then next thing they know, well, maybe not the next thing, but eventually they're sued.
Right. Well, it's a question of innocence, comparing innocence here. My clients did nothing wrong. My clients did not in any way contribute to the slandering of their title.
Well, what did they do wrong? I mean,
What they did wrong was, it could not have happened had they not signed that document.
They thought it was a good idea. They thought, okay, we're okay with that.
But there are consequences. You take an action, there are consequences.
In terms of being the fair share initiative?
But that's not all it did. If it were just...
It was couched. That's how it was presented.
It was couched.
And it was also presented with the advice of counsel. Counsel who, as I understood it, represented 500 other homeowners associations around the state.
The idea of the fair share, I know there's an implication or a tendency to feel sorry for these people as lay people that are just being told this, but the fair share initiative wasn't, if you feel like it, you can kick in. The fair share was, hey, some of your neighbors aren't kicking in, we need to come up with a mechanism to force them to kick in, and this is what's going to do that. That's not an innocent motive, that's a malicious motive to go after people that otherwise, if you'd let alone, never would have been bothered.
So if I'm a homeowner in the subdivision, I don't know your clients, and the directors say we've talked to an attorney, suggested we should amend our covenants to allow this to happen, so everybody pays $100 to keep the common area, et cetera, nice, and my wife and I think, well, that's a good idea. Sure, we'll chip in $100, then I'm somehow sued, and I'm on the less equitable side compared to your clients?
Well, my clients did nothing wrong. I'm saying they did something wrong. Their wrongdoing is less than that of the directors, I agree. Their wrongdoing is less than that of the attorney, I agree. But they are guilty of some wrongdoing.
Is there a good faith exception to this thing?
Well, that gets into the whole conditional privilege, the good faith belief and the validity.
Right.
In the brief, I outlined 7 reasons why we think it was improper for the trial court to dispose of that at a summary judgment level. The first one was that state of mind issues do not lend themselves to summary judgment determination. The second one has to do with the actual malice.
How could there be actual malice towards your client by these homeowners that didn't even know your client?
No.
The directors didn't know your client either.
But what they did know was that there was a group of homeowners that was not voluntarily contributing to this homeowners association. And what we do know is that they went out to create a mechanism to go after that group, the people who were voluntarily contributing, and create a mechanism where they would be compelled to, they could be sued, they'd be responsible for attorney's fees if they didn't pay, and my clients were part of that group that they went after. We made the analogy in the brief that...
I don't know how you, I mean, that's a matter of fact as far as you're concerned, but you haven't shown that the homeowners that you claim slandered your client's title knew that your clients were in this.
Well, we never got to that point. We never decertified the class to the point where they were actual parties that we were going after. What we do have is the association and the directors saying, we relied on the attorney, we had this belief, and we didn't have any malice against your clients separate from the malice that we had against the group of homeowners that weren't contributing voluntarily to the homeowners association.
Well, doesn't the undisputed fact of the consultation with the Attorney Larson, doesn't that refute actual malice?
I don't think that it does. I don't think those two were, the attorney's advice goes to the question of whether they had a good faith belief in the validity of the amended and restated declaration.
So you're saying you could have good faith but still have malice?
You could have a good faith belief in the validity of something and still have malice at the people that you're targeting with whatever it is that you're doing. But you never get to the malice if you establish the good faith validity or belief in the validity of it.
But okay, so the directors are sitting there saying, we think this is a good idea to do that, and we're going to consult with an attorney to say, how can we do this? And the attorney says, I'm very experienced in this area of the law. I've done this for many other homeowners associations. Here's what I think you do. If the people don't pay, it won't be a lien against their property. Draft this document. I've had success with these kind of documents. And the directors say, well, you're the attorney, we're paying you good money to do that, and we think it's a good idea, and we'll throw it out there to the homeowners and see if they want to do that, and then they all get sued.
Again, this was decided on summary judgment, not a trial. In the record is evidence that conflicts in terms of, did the attorney even say that this was legal? The directors said that he said it was legal at one of their meetings. When he was deposed, he said, I don't even use that kind of language. I would never say this is legal. Additionally, what we have in the record is his letter back in 2002, just regarding the question of the mandatory fee, not all these other aspects that were changed by the amended and restated declaration. He talks about it as a gray area. I can't guarantee anything unless there's 100% approval. Did he really?
The record, though, that he related to them the success he had in a very similar situation in Orange County where a court had validated the AO?
Yes, he did, but again, this is summary judgment. We've got a situation. We also have in the record another homeowners association where the former director testified in the deposition that when he asked him, is this legal, turning our association into a mandatory association, and the attorney's response was, if nobody files a suit, nobody complains, then we get away with it. Did the attorney really even believe that this was a valid amendment, a legal amendment to the original covenants and restrictions? I think that's a question of fact. That's something for a jury to decide, not something for a judge to decide on summary judgment. It's a state of mind kind of an issue, and the law in the state of Florida is, with very rare exceptions, and the appellees, cross appellees have pointed out one of those exceptions, that is just not something that's appropriate for summary judgment. Additionally, Your Honor, we think from the director's perspective, the state statute having to do with reliance on lawyers and all that sort of stuff does not apply to an intentional tort. This is an intentional tort. Additionally, we also have in the record the deposition testimony of the immediate prior past president of the association and the immediate prior past attorney of the association, where the attorney said, you can't do this without 100% approval, and she conveyed that to the sum of the directors. Again, at trial, let the jury sort this out. That's why God created juries. But this just is not something that's appropriate for summary judgment determination. And finally, Your Honor, the seventh reason why we think that was an inappropriate decision on summary judgment is if you take a look at the restatement of torts section having to do with the conditional privilege of rival claimants, there is no way that the cross appellees fit into the definition of a rival claimant. They did not record this in order to protect or preserve some interest they already had in my client's property. They did it to create a new interest in my client's property. They just don't fall within the definition of rival claimant. As far as their interest to maintain the community, if you say, well, we don't really care if they technically fall in or outside of the definition of rival claimant, if you allow them to raise some interest outside of what the restatement of torts lists as interests that can be protected by that privilege, then you're opening the door. What interests aren't sufficient to allow people to record documents against other people's title? If I wanted to create a situation where people were mandatorily required to contribute to the National Organization for Women, the NAACP, PETA, or something like that, could I come into court and say, well, my attorney said we could do that? Though I slandered the plaintiff's title, I had a good faith belief in its validity. So I think if you open the door and allow anything other than what's within the four corners of that restatement section to fall within the definition of a rival claimant, I think you're just opening Pandora's box. Lastly, Your Honor, the lower court entered an order that denied our ability to amend and expand the theories of recovery against the individual defendants. The second amended complaint that we filed with a motion for leave to amend raised basically four theories by which we could go after the individual homeowners. First had to do with agency. In the record of minutes of different meetings, membership meetings, where the attorney for the association said the association isn't doing this. This is something that the owners are doing. By virtue of the way the original covenants were written, it's the owners who have the power to amend or not amend. And that the association and its attorney acted as their agent to amend their declaration of covenants and restriction is a theory that I think we can recover against the individuals on. Additionally, there's conspiracy to slander title. None of this would have happened if all these people didn't have the same intent, the same idea to create the same mechanism to force my clients and other members of the community to pay these assessments and to fall under all these other things. Then there's just the general rule. Who is responsible? Who is legally responsible for slander and defamation? And it's anyone who assists or participates in the slander or defamation. It doesn't have to be the person who actually says the item. If you're instrumental in the actual commission of the slander or defamation, you can be included as a defendant in such an action. There's the conspiracy through force of numbers, the Walters versus Blankenship case. We think that for the lower court to take the position that looking just at the signature pages that the individual homeowners sign, where there's nothing false on those signature pages, we admit that. There is no false statement of fact on those signature pages. And there's no reference to my client's title on those signature pages. We agree, there's no dispute about that. But those signature pages on their face say that we're to be incorporated into the amended and restated declaration. And in the amended and restated declaration, my client's property, along with the property of everyone else in the subdivision, is mentioned. And the amended and restated declaration says now everybody's property is subject to the amended and restated declaration. So in closing, Your Honor, I know there's natural sympathy for these people that basically were snookered. These other homeowners, they got bad advice, but they're part of the problem. Without them, the problem never would have existed. Whether they can lay that responsibility off on the attorney, maybe there's some theory that they have to go after the attorney. We can't. We never relied on that attorney's advice. They obviously must have relied on his advice to some extent. I don't know, Your Honor. All I know is the law as it stands today, we can go after them, we can go after the directors individually to recoup the money my clients paid to clean up their title for the mess that the cross appellees made of it. Thank you, Your Honors.
Counsel, thank you.
Good morning. Wayne Tosco, Vasquez and Tosco, on behalf of the individual directors that served on the board at about the time of these amendments. I would like to, if I may, reserve 5 minutes for John Bengier, who represents the Homeowners Association, and will be addressing primarily this issue as to bringing in the other homeowners. This case has had a somewhat long and tortuous past, but it started in the early 2000s when the board of directors were approached by a number of homeowners about concerns of maintaining retaining walls, vegetation in the development. They had security that patrolled at night, and not everyone was paying for that. So they wanted to come up with some mechanism by which they could amend the amendments to make a mandatory paying assessment with no lien rights. Not a mandatory association that you had to join, but mandatory assessments. And that's when they hired Attorney Larson. I want to make an initial point here. There's two good faith or defenses that have been raised in this case. One is the common law privilege or good faith, and the other is the statutory good faith that apply to the directors individually, and that's 617.0830. What that provides for, and they use the word good faith in the statute, is that if the directors are acting in good faith, they have no individual liability. One of the things the statute specifically provides for is that if they're relying on advice of professionals, accountants, lawyers, those types of people. It's exactly what my clients did in this case. They didn't know how to go about this or whether they could accomplish it. They went and they sought the advice of Mr. Larson, who is a very experienced lawyer. He gave them an opinion in 2002. Admittedly, he said there were gray areas. They waited 6 years, came back to him. He said there had been some changes and developments in the law. He felt confident. He admittedly never said he was 100% certain it would be legal. He used the word that he was very confident that it would be valid. And he recommended a series of amendments that they could do to accomplish that task. Significantly, those amendments made for a mandatory dues or assessment association with no lien rights. It didn't create a mandatory membership. It didn't create lien rights. According to Mr. Larson, this would be valid, and this would get around some of the case law in Florida that said that you would change the scheme if you made it a mandatory association. So my individual clients relied on that information. They've all testified that they were confident that this will work based on what the attorney said. The attorney attended many of the homeowners association meetings, answered questions from homeowners, again relaying that he was confident that this would be valid and why it would be valid. Likewise, he sent a letter out to several homeowners who had inquired, in which he specifically stated this is going to be valid. We've had the same situation in 3 other associations. We also had a case in Orange County, in fact, where this was litigated and this amendment was valid. So relying on this advice, my clients went ahead with these amendments and had them recorded. They were recorded by the Larson Law Firm. They were drafted by the Larson Law Firm, and my clients followed their advice. The appellant's attempt to create some question of fact here by citing to the testimony of Coy Hilton. Coy Hilton was a director of a different homeowners association. According to Mr. Hilton, Mr. Larson told him, you can get away with it if no one sues. Mr. Hilton said, first of all, they were talking about a mandatory association, not mandatory dues fee paying. There'd be a mandatory, there'd be liens involved as well, something very different from what my clients were saying. Mr. Hilton also testified he never communicated that to the board of directors, to my clients, that comment. It's totally irrelevant. Brian Casey, they cite in their brief, was a homeowner at Sand Lake who was at a meeting, asked Mr. Larson, did you have to have 100% approval for this rather than 51% approval? And Mr. Larson was silent. He didn't respond. They suggest somehow or other that means my client should have known there would have been something wrong with the validity of this amendment. They also cite to Beverly Boyer, who was a former president from 1995 to 2000. Ms. Boyer stated that she had a conversation with the association's prior lawyer where he said you had to have 100% approval. Ms. Boyer testified that they were talking about a mandatory association. This was 8 to 15 years before they actually filed these amendments. A very different situation, a mandatory assessment, not a mandatory association, not a mandatory assessment. All those things are very important because Mr. Larson testified I was guiding the board of directors and the association in a way that would comply with the case laws that existed, not make it a mandatory membership, just a mandatory assessment.
Let me ask, how is the Bush's title affected or clouded by these amended covenants?
Well, what Judge Munyon ruled essentially is that because there was only 51% passed, it was not a valid amendment. It needed to be 100 because it changed, the 100% had changed what she called the general scheme or the common scheme of the development.
Okay.
In turn, their title was clouded because they wanted to sell their home. Presumably the next homeowner then, had they seen that, would have had to have complied with those amended bylaws and would have had to, and I believe it did require that new owners had to belong to the association as well, not just a mandatory assessment. So they claimed that in effect clouded their title. Now, they never tried to sell their home during that time period, but the judge ruled that was a slander of title. The other issue that the appellants have raised, going to this common law bad faith, again, from the individual director's point of view, they have a statutory good faith defense in this case that once they've raised that good faith defense, the case law is clear, there has to be the actual malice. And the appellants contend that 617-0830 does not apply because slander of title is an intentional tort. Well, in theory, it's classified as an intentional tort, but what's important is that there are only three elements to that. A false statement that is communicated to a third person and that disparages title. After that, it's what the courts call a fictitious malice or an implied malice. It's not an actual malice. It's not an intent to harm. It's an implied malice. If you raise a good faith defense, then they have to show actual malice. So it's a little misleading to call this an intentional tort in the sense that it is a way for the plaintiffs to get around to 617-083. It's just a fictional malice or an implied malice, but not an actual malice. So that statute still applies. As a common practical matter, if the courts were to rule that this statute didn't apply in a slander of title, any time a board of directors approves the filing of a lien, it happens thousands of times throughout the state of Florida. If the lien turns out to be improper, then they're going to have individual liability. That you couldn't get anyone to serve on a board, and that's exactly what this statute is designed to protect, situations like this. Lastly, in terms of the common law good faith defense that has been raised in this case, that applies as well. The appellants have gone through a great effort here to attempt to patch together cites from Prosser, from the various cases, and suggest that a good faith defense only applies in situations in which there is what they call an offensive use of the good faith defense. Not sure what that means, versus a defensive or protective use. And that just flies in the face of several Florida cases that I think address this issue and answer the issue in favor of the directors and the homeowners association. For example, in residential communities case, which is a 5th DCA case, The homeowners association had amended their bylaws and their documents to require it to be 55 years or older to be part of the association. The developer owned a number of units and did not vote in favor of that. The developer sued for slander of title and was successful. But the homeowners raised the good faith affirmative defense in that, and the courts allowed that affirmative defense in that circumstance. That's very similar to what we were doing here, trying to amend the bylaws. We amended the bylaws. The court said that that doesn't fly, it's a slander of title, but we're entitled to that good faith defense. It's no different. Likewise, in the Ocone case, it was a architectural firm in Georgia, did some work for a hotel in Florida. They weren't paid. They filed a lien against the hotel with the advice of an attorney, incidentally. The hotel filed a suit for slander of title. They raised the good faith defense. The court there found that the architectural firm was not licensed in Florida, were not even entitled to recover their fee, and certainly had an invalid lien. It was a slander of title. But the court allowed that good faith defense in those circumstances. The last case is one in which it was the Escondido case, I believe it was. No, I'm sorry, the Tower Hill case, in which the developer built a condominium. The homeowners association had problems with the building. They filed a lien for these alleged defects against the developer's individual units. There was a slander of title. They weren't entitled to that lien, but they were entitled to good faith defense. The point of all those cases, Your Honors, is that in each of those cases, the homeowners association did not have an existing interest in the developer's property, didn't have an existing interest in the hotel, but yet they still had a good faith defense that they were entitled to raise because they had a good faith basis to assert the lien or to amend the documents. So in this case, we're certainly entitled to good faith defense to directors because of the statute, and both the directors and the association because of the common law good faith defense. And then there simply are no questions of fact in this case. That, again, the burden shifts to the plaintiff to show malice or a lack of malice, to show malice, I'm sorry. And the definition of malice is an evil motive that amounts to a willful or wanton wrongful act. And they simply presented zero evidence that my clients acted in that manner. And in fact, all the evidence is to the contrary. They relied on the attorney. They did a good faith effort to try to do what was right in filing and amending these in order to get everyone to share in the maintenance. Thank you.
Counsel, thank you.
Good morning, Your Honors. John Bengier. I represent the Homeowners Association in this lawsuit, and I'm up here to principally address the amendments. Mr. McNeil, when he got up here, he talked about the amendments. He said we should have been allowed to amend the complaint to bring in the individual homeowners, and he listed some theories. First of all, agency, that the Homeowners Association or the Board of Directors is the agent of the principal, being the homeowners. And Judge Munyon had to consider all these things, and as you know the law, you can amend. Florida is a liberal amendment state, but there's an end to how far and how many times you can amend, and if you can't state a cause of action, then you shouldn't be allowed to amend. And so Judge Munyon had to consider these things. And so when you take this as to what they're offering, you can't state a cause of action based on agency if the agent has done nothing wrong. In other words, the principal, the homeowner, is part of this agency relationship with the Homeowners Association. Well, if Judge Munyon found already by the summary judgment that the Homeowners Association and the Board of Directors did nothing wrong, then how could it be that the principal did anything further than his own agent? So no cause of action could be stated. The other causes of action related to conspiracy and things like that, Judge Munyon said, where is your act? Tell me, what you're going to plead here is the act that's going to support this. And the plaintiff said, well, the act is they're signing this consent. And so Judge Munyon said, well, can you all go out there and do some legal research for me and find me any case whatsoever that supports where a vote by anyone could be the basis of a cause of action, which you all were kind of pointing out here earlier when you're saying, my gosh, you've got a homeowner, who's getting the advice of counsel, their board, and they simply raise their hand and they're liable. No one could do that for Judge Munyon. We certainly couldn't. We went to Westlaw. Plaintiff was given the opportunity. They couldn't do it. So Judge Munyon was then put in this position. What is the act? If the act is simply signing this consent form that simply says, I agree to be bound and nothing more, that doesn't support a cause of action. And I put it in my brief, the public policy consideration here of allowing this to go forward and the chilling effect it would have on any homeowner out there that considered, well, do I raise my hand here? I think this is a pretty good idea. I've got the advice of this counsel up here who's in front of us saying that it's lawful, but boy, if he's somehow wrong, I'm personally liable, I'm not going to vote for this. Nothing would ever be accomplished. Same thing for these poor directors who are under the guidance of this attorney who holds himself out as a specialist in this area and tells these people, I'm confident based upon the law that this will be upheld, and they follow his lead, they're somehow personally liable. To address issues that the plaintiff was making, almost any time there's a vote, you're going to have somebody that's in favor of it and somebody that's resisting it. An example, let's say you wanted to change the rules to say, nobody can...
People in condominium associations.
Yes.
In homeowner associations, they don't always get along about everybody having a
Correct. And I was involved in one of those where I don't want anybody to be able to park a boat in front of the home, okay? Boat owners, said, I don't want this. Everybody else, I don't want boats parked. So you've got this vote, and you've got resistance. Now, that would be malice because I don't want boats, parked in front of lots. Plaintiff also pointed to Rick Larson and says, well, Larson, the evidence may show that Larson wasn't so convinced as he was telling the board. They brought in some other attorney that said, well, I disagree with Larson. Looking at the law, I think he was making a mistake back then. Well, the issue is not Larson's state of mind. The subjective state of mind that's important in these cases is that of the board of directors and what they were being told by Larson and what they were basing their decision on, not Larson's state of mind that the plaintiff is trying to impugn. And with the Boyer, I think this was pointed out that the past homeowner president sought advice of counsel and was told you need 100%, but we're talking apples and oranges. She also testified that the advice she was seeking related to mandatory membership. Larson was smart enough, based on Holiday Pines, to say, you know what, I know you can't do that. I'm going to tailor an amendment that falls within Holiday Pines and all these other cases out there so that I can accomplish the end that you want to achieve, maintenance to support all the things that the homeowners association is providing all the members without getting you into trouble. And they follow his lead. That's what was done here. Thank you.
Thank you, Councilman.
It's just to address a couple points raised by the cross appellees. One point raised by Mr. Tosco was that apples and oranges, mandatory associations versus what happened here. Judge Munyon, in the case below, in her order finding this amended and restated declaration to be invalid under the Holiday Pines original scheme of development theory, states, and I'm reading from page 13 of the initial brief, the undisputed facts establish that the ARD purports to convert a voluntary and intermittent homeowners association to a mandatory, continuously existing association upon the transfer of the property with mandatory dues. There's really nothing about the amended and restated declaration that's not mandatory. It's mandatory that you pay your assessments. It's mandatory that you pay your dues. It's mandatory that you pay the fines if they impose fines. It's mandatory you obey the rules and regulations if they impose new rules and regulations. There's nothing about it that's not mandatory. As for Beverly Boyer, we've got a quote on page 13 of our reply brief. That's the same phraseology that the directors were using. They said, we're going to make it mandatory. We're going to make it a mandatory association. She didn't say just mandatory as to membership. That wasn't the opinion the prior attorney of the association had. It was a mandatory association. To create a mandatory association, you need 100%. Evidence in the record, again, great at trial. They can make their arguments, we'll make our arguments. Summary judgment, not so great. Actual malice, Mr. Tosca gave a definition of actual malice that was partially correct. The definition from the Bothman v. Harrington case is actual malice necessary to overcome the good faith privilege defense is defined as, quote, ill will, bad or evil motive, or gross indifference to or reckless disregard of the rights of others, as will amount to a willful or wanton act. If it includes ill will, how is it not ill will to create a mechanism to force people to pay money they don't want to pay? Is that not ill will against those people? The Escondido case, Mr. Tosca tried to bring some cases that did not apply the rival claimant definition that's in the restatement. The Escondido case, if you look at the facts of that, they passed an amendment in the first Escondido case that the 5th District decided. They said, well, this doesn't affect the developer's property because in the condominium declaration, in order for it to bind the developer and his property, he has to consent to it, so it just doesn't affect it. So in the second case, when they wrote the opinion, they say it's not slander of title because it doesn't affect your property, and you acted in good faith, blah, 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 blah. Pure dicta. The mechanics lien case that was mentioned, a mechanics lien is the classic situation for a rival claimant. The mechanic lien, the mechanic has his goods, has his services in the property that haven't been paid for. He's afraid that some third party is going to buy the innocent third party without knowledge of his claim is going to buy the property, so he needs to record something in order to preserve his situation. There might be something technically wrong with the claim of lien. In this case, it was an out-of-state architectural firm. Nevertheless, they're protected because they are a rival claimant. They both claim interest in the same thing. The other case mentioned, or in all three cases, none of them reached the issue of whether or not somebody constituted a rival claimant or not within the definition in the restatement. That's an issue here. That was an issue in the Dixon case. That was an issue in the Bar Harbor Banking and Trust case. Mr. Bengier's comment about this was just a vote and all they did was agree to be bound by it. No. Fair share initiative was not, are you willing to pay your fair share? No, fair share initiative was, hey, there are people over here who aren't paying their fair share. Let's force them to pay their fair share. Ill will. Again, I feel sorry for these people that signed those joiners' consent, but they signed them. This never would have happened had they not signed them. They knew what they were signing. They knew what the effect would be on their neighbor's property who weren't going along with this. I'm sorry. They slandered their neighbor's property. They're responsible. Can they lay it off on somebody else? Possibly, probably, but as the plaintiff, that's not my problem, that's their problem and their attorney's problem to find other people to lay that blame off. But within the law as it stands, they are liable. They're additionally liable, as well as the directors and the association. Thank you, Your Honors.
Thank you, counsel.